All right, here we go. Welcome back to the Conscious Effort. On tonight's stream, I just wanted to take a look at Bill C-220 through a conscious lens. I want to take a look at it through like a little bit more of a grounded lens and not from a left angle or a right angle, but more from like a place of awareness or clarity, I would suppose, and just all around genuine curiosity because I'm really curious as to how our justice system really works here in Canada. There's been a lot of noise around this bill and a lot of fear, especially where it deals with people from outside of Canada and being deported and whatnot. And there's been a lot of assumptions. So I say let's crack into it. We'll take a look at it. It's Michelle Garner Rempel. She's a conservative MP from Alberta, I believe, and she's the one who's bringing this forth during the private section this evening. And so she had brought this motion forward tonight, and they literally just got out of the house this evening about an hour ago or so. So let's slow it down. We'll unpack what it actually says, why it matters to us as Canadians, and what it might mean for us moving forward. So let's take a breath, let's settle in, and yeah. Like I said, my mantra is with an open heart and an open mind, and let's take a commitment to understanding the bigger picture here. All right, so let's jump in. Here we go. So that, like I said, I've explained it all. This is Michelle Rempel and Garner, and this is Bill C-220.
Ms. Rempel.
This consideration at second reading of Bill C-220, an act to amend the Criminal Code, Immigration Status and Sentencing, standing in the name of Ms. Rempel-Garner.
Ms. Rempel-Garner, seconded by Mr. Redekop, moves that Bill C-220, an act to amend the Criminal Code, Immigration Status and Sentencing, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate. The Honourable Member for Calgary-Nose Hill.
Mr. Speaker, should judges be allowed to use a non-citizen's immigration status to issue a more lenient sentence to a non-citizen convicted of serious crimes like sexual assault, just so that they can avoid deportation? The answer is no. And tonight, I'm pleased to speak to Bill C-220, the One Law for All bill, which represents and reasserts the principles already laid out in the Immigration Refugee Protection Act with regard to the deportation consequences associated for non-citizens convicted of serious crimes like sexual assaults in Canada. The vast majority of people in Canada who have immigrated here abide by our law. So removal from Canada for non-citizens after being convicted of a serious crime is a no-brainer to protect everyone, the value of Canadian citizenship, and frankly, just every person who resides in our country and plays by the rules. After a decade of liberal post-nationalism and excessively high immigration levels, accepting this change would allow the government to demonstrate respect for Canadian citizenship by affirming that at a minimum, the privilege of residing here for non-citizens depends on adherence to the rule of law. And everything that I've outlined, and that I will outline tonight, will show that beyond rote partisanship, there is no reason for the government not to support this bill. In fact, to save Canada's pluralism, the government must start admitting its errors with regard to immigration and working across party lines to accept common sense solutions. Colleagues, recent public polling shows that support for immigration among both Canadians and newcomers is at an all-time low. This opinion should shock and spur every person in this place to action to find ways to solve this problem. And that's what I'm trying to do here with this bill today. Thankfully, the reason why Canadians don't support immigration the same way they used to is not because Canadians are pointing the fingers at immigrants. Rather, Canadians who are unhappy about immigration are pointing their fingers where the blame should be placed, at the federal government who has, over the past decade, brought too many people in too fast for housing, healthcare, and jobs to keep up, while simultaneously legislating a doctrine of post-nationalism that asserts that there is no Canadian national identity, which includes things like an equanimous judiciary for non-citizens to integrate into. But Canada is at a tipping point. The government must quickly act to restore an immigration system that they broke. And if the government won't act, which it hasn't, then Parliament must. So in the spirit of nonpartisanship, I have used my private member's bill slot to correct one of the many areas that the government needs to act on to fix the immigration system. Later tonight, myself and my colleagues will move many amendments to Bill C-12 in a further effort to do the same. But back to this bill. To be fair to everyone and to start to prevent the further erosion of Canada's tolerance for immigration, we must ensure that non-citizens who commit serious crimes like sexual assault face the consequences that are already set out in our law. At a bare minimum, colleagues, non-citizens who abuse the great privilege of being in our country by committing a serious crime like sexual assault should face the deportation consequences that are already outlined in the Immigration Refugee Protection Act. And here's how we can do that. The bill before us tonight amends the criminal code by adding a new general sentencing principle under Section 718. This is the section of the code where Parliament has...
Okay, so here's where she's going to dig into it here now with what she's proposing that needs to be changed and amended in this Bill C-220 in our criminal code regarding people from away. Here we go.
Exercised its right to provide guidance to the courts on how convicted offenders ought to be sentenced. My bill proposes to add a simple one-line new principle under Section 718.202, which states that when sentencing a convicted criminal who is not a Canadian citizen, a court shall not take into consideration any potential impact the sentence could have on the offender's immigration status in Canada or on that of a member of their family. This simple one-line provision ensures that provisions that are already outlined in the Immigration Refugee Protection Act are enforced in sentencing non-citizens convicted of serious crimes like sexual assault. That is the how, but here is the why. In recent years, there have been multiple instances of judges issuing sentences to non-citizens convicted of serious crimes that were designed to allow them to evade deportation. The net effect of this practice in considering a non-citizen's immigration status in order to give them more lenient sentences to avoid deportation is to create a two-tier justice system between non-citizens and those with Canadian citizenship. This is unfair and it is antithetical to the principles of fundamental...
Just to add to that, just the other day, the police in Ottawa cleared 2 Khalistani citizens of gun charges of having illegal firearms and dropped the charges on them. Would that have, just saying, would it go both ways? Me being a legal gun owner, I have my PAL. If I got caught with that, what would happen to me, right? Just saying, wonder, let's say.
Fundamental justice and has eroded Canada's immigration consensus. Here are but a few examples of the rampant, excessive number of times non-citizens convicted of serious crimes like sexual assault have been issued two-tiered, lenient sentences in very recent history just so that they will avoid the deportation consequences already set out in the law. A non-citizen from India pleaded guilty to no fewer than 4 counts of voyeurism, which left his female victims with intense fear and anxiety and emotional distress. He was sentenced to 5.5 months jail. Why? Despite the judge admitting that 6 to 12 months would have been a more appropriate sentence. This was to avoid deportation, and the judge even said this. In a 2024 Calgary case, another non-citizen from India was granted a conditional discharge for attempting to purchase sexual services from a 15-year-old girl.
Wow.
They did this to allow him to preserve the eligibility to become a Canadian citizen and avoid deportation. The judge cited
is
in
that the
sentence
people we want here?
devastating collateral immigration consequences of a harsher penalty. What of the victims? A non-citizen in Canada on a visitor permit was convicted of twice groping an 18-year-old woman's genitals under her skirt as she stood at a bar to buy a drink. This person, this non-citizen, received a discharge from the judge so that he could have a deportation appeal. In March 2024, a 24-year-old non-citizen from Surrey, BC, received a conditional sentence of 2 years less a day for aggravated assault and possession of a weapon after stabbing a stranger. Sounds serious, right?
These are the people
What did
they're
the
letting
judge do?
into
The
our
judge
country.
rejected the Crown's 4-year jail recommendation so that the non-citizen would be able to avoid deportation. In October 2025, just last month, Roosevelt Rush, a non-citizen from Jamaica, had his cocaine trafficking sentence halved from an expected term while already serving 6 years for fentanyl and firearm offenses because the judge wanted to help him avoid deportation. In 2024, in BC, a non-citizen was convicted of fraud and received a 6-month sentence, which a judge shortened from 10 months so that he could what? Avoid deportation. In 2024, a non-citizen from Somalia was convicted of assault with threats against police and had their jail time cut short to evade deportation too. This one was a refugee who committed these crimes while getting the benefit of Canadian sanctuary. All this consideration for non-citizens convicted of serious crime to avoid deportation. But what about the victims? What about the value of Canadian citizenship or the responsibilities associated with being in our country? Being in Canada can't just be about receiving the privileges and the benefits of being in Canada, which are great. It also has to be about adhering to the responsibilities associated with that privilege, and that includes adhering to the rule of law. There are many other examples that illustrate the trend of immigration status being considered in sentencing, with criminal lawyers now routinely arguing for lighter sentences so that their non-citizen clients can evade deportation or denial of citizenship under IRPA's current provisions. Let me explain why this is happening. Ever since the Supreme Court ruling in R versus Pham, the courts have been giving greater consideration to collateral immigration consequences when sentencing. To be clear, this court ruling explicitly ruled that this consideration does not constitute a charter right or a remedy or a charter breach. In fact, this ruling doesn't even mention the charter once. Further, the court ruling also made clear that the flexibility of our sentencing process should not be misused by imposing inappropriate and artificial sentences that, in fact, to do so would circumvent Parliament's will. That is clearly not what's happening. Activist judges have taken this ruling as evidenced by the proliferation of examples that I have given and twisted it beyond its scope in order to allow non-citizens who have been convicted of serious crime to get more lenient sentences to avoid deportation. That is what is happening. Meanwhile, Canadians would not be given the same consideration. So we have a two-tier justice system. The will of the courts cannot be trusted if it is allowed to go unchecked, as it clearly has in all of these cases. My friends and colleagues, it is long past time for Parliament to exert its will and rein this poison in. To be very clear to every colleague here, the Supreme Court has been clear that the people of Canada who are concerned by crimes committed by non-citizens have every right through their elected representatives to provide guidance to sentencing judges. And that is exactly what this simple, common sense, nonpartisan bill does. Just this morning, the Globe and Mail editorial board said that judges in our current system are protecting non-citizens from the consequences of their criminal conduct, lamenting that no one seems to consider whether Canadians would want these offenders as citizens in the first place. This is the Globe and Mail. While it's tempting to blame judges for this state of affairs, the fault lies with the federal government, who, in spite of the increased evidence of leniency,
It's not the judges who are letting all these people into our country is the thing, but it's the judges that are being persuaded to give lenient sentences. They just probably don't want to deal with the paperwork, man. Everybody's tired. Everybody's tired. We're being taxed to death so we can support people. And so it's like the people that it seems like there's a lot of bad people slipping through the cracks I personally am all for like quality immigration. If we bring in good people into our country that help and benefit our country and aren't using us and using the system, who are looking for a hand help up instead of a hand out, you know. Like, I understand that people come from terrible places and that there's lots going on, but when you got people that aren't from here and they're committing crimes and hurting people and doing violent crimes to women and to children, and these are despicable people, why are we letting them into our country in the first place? So that's kind of where my heart is on that. But I mean, there's lots and lots of good people out there. So, but we're not talking about the good people right now. So, anyway, I'm getting winning. I'll let Miss Rempel keep going. Mark Garner, go continue.
And sentencing due to consideration of immigration status in recent years have declined to provide more clarity to judges through legislation. This is why I introduced this bill to amend the criminal code and rectify this issue. The rationale for this change is straightforward. Anyone seeking residence or citizenship in Canada, as I said, has responsibility as well as rights. The Citizenship Guide clearly states that citizens must obey Canada's laws and respect the rights and freedoms of others. And IRPA outlines the potential consequences for non-citizens who fail to do so. A non-citizen in Canada should accept individual responsibility for defending the democratic institutions of Canada's constitutional monarchy, which is an ordered liberty rooted in the principles of peace, order, and good government. In practice, this means they will defend shared Canadian rights like freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of speech, of the press, freedom of peaceful assembly, freedom of association, and the equality of women and men. All Canadians and those seeking to become one are expected to abandon any violent, extreme, or hateful prejudices and to contribute to Canada. And they are expected to respect the rule of law and accept the consequences for not doing so. Without legislative clarity on considering immigration status in sentencing, judges can apply aspects of the Pham ruling to undermine the principle that non-citizens, that principle for non-citizens, effectively end running the deportation consequences already enacted by Parliament that exist in IRPA. To those who would say that this bill offends the principle of judicial independence, I want to make it clear that it is entirely appropriate for Parliament to offer guidelines to the courts on sentencing. Section 718 already does this in countless ways, but I will highlight 4 examples. 1, the very beginning of Section 718 in the Criminal Code states in part that the fundamental purpose of sentencing is respect for the law. I would argue that Canadians lose respect for the law when it is not applied equally, and it has not been done in the case of non-citizens convicted of serious crimes like sexual assault. 2, Section 718(1) states that a sentence must be proportionate to the gravity of the offence and the degree of responsibility of the offender. I would assert that at no point has Parliament intended to say that the responsibility of the offender is reduced because of their immigration status. To suggest otherwise is to remove agency from an individual just because they were born in a different country, and that's wrong. 3, Section 718(2) lists the following as an aggravating factor for the purposes of sentencing: evidence that the offense had a significant impact on the victim considering their age and other personal circumstances, including their health and financial situation. Many of the cases I highlighted tonight involve sexual assaults, which obviously have a significant impact on the victim and disproportionately impact women. Our bill will seek to reestablish this general sentencing principle that has too often been ignored. And finally, Section 718(2) states that a sentence should be similar to sentences imposed on other offenders for similar offenses committed in similar circumstances, obviously giving the offender a lighter sentence just because of their immigration status offends this principle. It is well within Parliament's purview to reassert this general sentencing principle by further clarifying for judges that they should not take into account an offender's immigration status. And in my closing remarks, Mr. Speaker, I would like to thank Sean Phelan, an unsung hero in Canadian history. A lot of people won't know this name, but he has single-handedly worked to reform Canada's justice system over the last 10 years, and I thank him for his help in this bill tonight. Thank you.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I'll have a bit of time to expand. On some thoughts shortly, but I do have a question for the member. You know, the reference that she always makes to is sexual offenses. There are many different types of offenses that a person can commit. You know, I've had opportunity to have to tour quite a while ago prison sites where gambling addictions leads to a lot of types of crimes that ultimately have a person go to jail. It's just not sexual offenses. I just mentioned that to the member, and I'll expand on that shortly. But my question for her is, does she have any genuine confidence in judicial independence?
The honourable member for Calgary Nose Hill.
I outlined in my speech why my bill upholds the principle of judicial independence. And it also outlines how the Pham decision actually intended for the courts not to do exactly what they're doing right now, which is to avert the will of Parliament that has already been exerted in IRPA, which clearly states that a non-citizen convicted of a serious crime should be deported. And my colleague is introducing this principle that somehow a crime like fraud or drug trafficking or other offenses, if somebody reaches the threshold of serious criminality in IRPA, they should be deported. They should be, and he laughed at this, and this is what's wrong with for everybody watching at home, Mr. Speaker. The Liberals laughed at that principle that undermines, it underpins Canadian citizenship. Ha ha, if you commit a serious crime, you should stay here if you're a non-citizen. It's garbage.
Questions and comments. Question commentaire. The honourable member for Skeena, Bulkley Valley.
Thank you, Mr. Speaker, and thank you to the member for that very knowledgeable speech. I have a tough time keeping up with it. It's a very complicated subject, but the premise of it is pretty basic in terms of the crimes being committed. Now we hear Liberals trying to equate sexual crimes with gambling crimes. There's a specific victim when you're talking about women and children being victims of sexual crimes.
That's right.
And I don't want to leave this house with the idea that we should be diluting this just because of a status of an immigrant. So I'd like to ask a colleague, when we're talking about the victims, can she elaborate that in terms of the victims, especially when we're talking about murder and missing women and violence against women that the Liberals profess to stand up for?
The honourable member for Calgary Nose Hill.
So I'll speak to two provisions briefly. In the criminal code already, the criminal code states that sentencing needs to consider the impact on a victim. So my colleague is absolutely right. But also in the Immigration Refugee Protection Act, it also clearly states that somebody who is a non-citizen who's been convicted of a serious crime, any serious crime, because there is a victim in any crime, especially serious ones, they should be deported. What has happened through the Pham decision is that activist judges have perverted the original ruling and subverted the will of Parliament and proliferated a set of leniencies for non-citizens convicted of serious crimes, like sexual assault, and undermined public confidence in both the justice system and the immigration system. That is no way to uphold a pluralism. In fact, that is how a pluralism will fall apart, and maybe that's what the Liberals want. After a decade of post-nationalism saying that there's no national identity and eroding the rule of law, that's where we're at. They need to support this bill.
Question commentaire. Member for Peace River Westlock.
Well, thank you, Mr. Speaker, for bringing this bill forward. It's a great bill. I'm wondering if she can just outline, we've heard in the past about stories of judges actually reducing the sentence so that particular peoples don't get deported. This to me totally seems like a way of reducing the value of Canadian citizenship. I'm wondering if she can comment about that.
The honourable member for Calgary Nose Hill, and she'll have 55 seconds to respond.
This is why this bill is so important. In order to preserve the value of Canadian citizenship, we need to understand that there are responsibilities associated with being in Canada, not just privileges, not just benefits, right? In order to have those privileges and benefits, there are responsibilities. And a bare minimum, as outlined in the Immigration Protection Act already, is to not get convicted of a serious crime. IRPA says that if you are a non-citizen and you are convicted of a serious crime, you should be deported. And I'm sorry, the will of Parliament needs to be supreme. I'm actually not sorry, to be clear. Parliament needs to assert its will, rein in these activist judges, and do what the federal government has not done, which is let them run amok for a decade and let them undermine the value of Canadian citizenship, not seek restitution for victims, and also make it unfair for every immigrant who comes here who plays by the rules, who is most immigrants. This is a no-brainer bill. Every week there is a story of one of these. And every week, if the government does...
I have to interrupt the honourable member. Resuming debate, please du débat. The honourable parliamentary secretary to the government house leader.
Yes, thank you, Mr. Speaker. And in many ways, I disagree with the motivation that's been brought forward with respect to this piece of legislation. The member herself even made reference to the fact of what's happening from public opinion.
So this gentleman here that's speaking, he's the Liberal, and he was the guy that you heard go, ha, across, well, she was speaking earlier. So we're going to hear his perspective on it now.
Opinions in regards to immigration in general. Is there any surprise that the Conservatives like to feed that perception, Mr. Speaker? And we see that with a number of actions and statements that they actually make. You know, even when I posed the question, she responded to my question by saying, I laughed, that the Liberal Party laughed. That's just not true, Mr. Speaker. Mr. Speaker, that is just not true. And if at the end of the day, they take a look, and I would suggest that they look in terms of what happened. I did not laugh, Mr. Speaker. I take the issue very seriously. What I see across the way is a Conservative Party that does not take the issue of judicial independence very seriously, nor do they have any concept of what it is in terms of policy, good, sound public policy that's in the best interest of Canadians and permanent residents. What they like to do is to take the extremes and then exacerbate on those, Mr. Speaker, to the degree in which they feed anti-immigrant feelings in our country. And I say shame on them. I think it does a very strong disservice to Canadians in general. Think in terms of a permanent resident. Number one, you can have a permanent resident living in Canada for 40 years. Do you know permanent residents are actually family members of many members of a family, some of which do have citizenship? Let me give you an example of one file that I had that was not that long ago. Imagine a father married with a number of children. I believe he had 3, it could have been 4, might even been 5. It was at least 3 children, Mr. Speaker. They were all citizens, but he was not, Mr. Speaker. For a number of reasons, he was not. He was a permanent resident. And yes, there was an incident that involved drugs. And at the end of the day, Mr. Speaker, I believe that at the... Well, you know, it's really shameful in terms of the allegations that are being thrown across the way about buying sex and sexual violence, attributing that to the individual that I'm talking about. Shame on you. Understand the system before you start leveling the type of allegations that you have. You know, for in their mind, you know, they need to be a little bit more understanding in terms of what happens in our communities. There are things such as individuals making a bad decision. And sometimes, Mr. Speaker, it does not necessarily justify a deportation. In some cases, it does not justify it. That there could be extenuating circumstances that do need to be taken into consideration. Yet they stand back and they say nothing. Where's that caring attitude for real people that are not committing the type of crimes that have been referenced by the introducer of this particular legislation? At the end of the day, Mr. Speaker, the types of crimes that are being suggested, they're going to be deported anyway. If someone is going out there and raping another individual, do you really believe that they're going to get special treatment from a judge that goes before a court? I don't think it's nowhere near to the degree in which the Conservative Party is trying to put on the record. And I would suggest to you, it does 2 things. Number 1 is it shows and clearly demonstrates that they do not have respect for judicial independence, Mr. Speaker. They don't respect judicial discretion. They talk about the rule for law, but take a look at the legislation that they have brought before the House. Legislation that questions consistently judicial independence and their ability to be able to have judicial discretion. Consistently. They bring in legislation that is not charter-proof, Mr. Speaker. They're prepared to walk on the rights of Canadians, and I would even suggest to you permanent residents. Not everyone gets a Canadian citizenship and has been here for 40 years, and they don't for a number of different reasons, Mr. Speaker. And it affects all communities. So if you stand up and you're going to a multicultural event, tell them to their face, why don't you, in terms of your feelings, that because you're here for 30 years, you should not be treated like a Canadian, Mr. Speaker. Shame on the Conservative Party. We live in a multicultural society, and there are good reasons why constituents in which they represent do not have a Canadian citizenship. There's well over 1 million plus. I would suggest to you it's probably over 2 million people that live in Canada that have been here for years and years and years, and they do not have a Canadian citizenship. And at times there might be some of them that fall on the other side of the law, Mr. Speaker, and it doesn't necessarily mean that they are bad people and have to be deported, Mr. Speaker. In certain situations, yes. But the difference is, Mr. Speaker, is that we believe in judicial independence. We understand the necessity of having discretion for our judges, Mr. Speaker. They need to, they were talking about immigration numbers. She made reference that the high immigration numbers. Let me remind the Conservatives. I was actually in the opposition when Stephen Harper back in 2014 said we want to increase the number of temporary students and instructors to over 400,000 in terms of temporary permits. And guess what? By 2022, that was a Stephen Harper commitment. And then following that, you had a pandemic. There's a reason why we have the situation that we have today. And yes, Mr. Speaker, there is responsibility on all all of us, on all sides, to try to do what we can to stabilize our immigration, temporary visas, and so forth. But to consistently, we hear from conservatives that downplay the importance of immigration. They have a lack of respect for permanent residents, Mr. Speaker, and we've seen a good example of that today. I would suggest to you, Mr. Speaker, that the Conservatives need to stop thinking about their far-right movement that's within their caucus and start thinking in terms of what's in the best interest of Canadians, Mr. Speaker. This is legislation, as you can tell, I won't be supporting. I do not see the merits for it. I think it's a betrayal of judicial independence. I believe it's a betrayal of judicial, or allowing judges to have discretion. They have not demonstrated at all that the judges as a whole have not used a proper discretion. They have not demonstrated that. Yes, there could be individual cases that are out there, and I have not heard the great details on those cases, Mr. Speaker. And I can tell you that many of the types of cases that you hear today are the same types of cases that would have been there when Stephen Harper was the Prime Minister and the leader of the Conservative Party sat around the Conservative caucus. But at that time, they didn't do a thing, Mr. Speaker. Why? Because they, today, are so far to the right, they want to appeal and say things that is ultimately, I would suggest to you, as being anti-immigrant, Mr. Speaker. And that is the reality. That is the type of things that we're seeing from the Conservative Party as they make that shift even further and further to the right. No wonder why Joe Clark said that he didn't leave the Conservatives.
He seems really angry. Like, I don't think she sounded like anti-immigrant at all. She was not talking about law-abiding people that come here. She's talking about violent criminals and stuff, and he just seems really, really angry. I don't know. That's just my observation, that he seems really mad, and like it's like one of the. I find if it's one of those moments where it's like, if I yell really loud, maybe my point will get across. But it's like, I don't know. What do you guys think? Tell me what you think. Let me know. Tell me in the comments. It's pretty crazy. I'm new to politics, so I'm learning about it here with you guys. So.
The Conservative Party left them, Mr. Speaker. That's the reason why we have Kim Campbell feeling so uncomfortable with today's Conservative Party, Mr. Speaker. Is there any wonder why, at the end of the day, the Conservative Party needs to start seriously doing some internal review? And I hope, we'll wait and see what happens to their leader of the Conservative Party. I suspect he might get a few bumps, but at the end of the day, I suspect he'll survive because the majority of the caucus is far to the right, based on the types of things in which we've been hearing in terms of, well, we don't want the government to invest into social programs. There is no role for the government of Canada to build on social programs, whether it's health care, pharmacare, dental care, food for children, child care programs, supporting our seniors. Why? Because the far right in the Conservative Party does not like government, Mr. Speaker. And that's the type of thing that we're seeing more and more of coming from the Conservative Party of today inside the House of Commons. And albeit, good luck. I hope you're in opposition for many, many more years to come, Mr. Speaker. I would hope that common sense will prevail and this legislation will not even make it.
Order. And I'll remind the member not to address comments directly across the floor, but through the chair. Resuming debate. Reprise du débat.
The Honourable Member for Rivière du Nord. Thank you, Mr. Speaker. Mr. Speaker,
Order. Let's have a little bit of order.
Getting crazy in there. This fellow's from the bloc, Quebecois.
Can begin his speech.
Getting wild in the House of Commons.
Thank you, Mr. Speaker. Mr. Speaker, this bill is worthy of study. The principle is worth studying. And it's worth studying, and the criterion of an accused immigration status is something to consider. And when you read this bill, you get the impression that the sponsor thought that this should be the deciding factor. But no, that's not what the Supreme Court said, and it's not what we think. If someone's immigration status is, if their status is precarious and they commit a crime and they're to be punished, well, I think that's outrageous. But it's one factor among others. That's what the Supreme Court said. It shouldn't be the sole factor. So you need to distinguish, for example, Mr. Speaker, between, you have to draw a distinction between a scenario where a drug trafficker who's already been convicted and who's under arrest and then gets caught again and says to the judge, well, I'm not a citizen yet. Well, I'm not going to shed a lot of tears over that person's case. I don't think it would be a big loss to Quebec society or Canadian society if someone like that were deported. But there's another scenario where a single mother of 3 young kids, she's here and she loses her status. She has a work permit that's expired and it wasn't renewed for all kinds of reasons, for administrative reasons. The children have nothing to eat. And she gets caught trying to steal some food from the grocery store. It's an offense. It's shoplifting. But are you going to send that mother back to her country of origin? And I don't think the judge should find the victim, the accused, should acquit them. They committed the crime, they're guilty. But should that be taken into account, their status at the time of sentencing? I think so. So you have 2 scenarios here, where a mother steals some food to feed her family, and someone else who steals it for another reason. It might even be the same offense, but I think the person's immigration status has to be taken into account. And that's what judicial discretion is all about, or human justice, if you will. And in Quebec, we believe in that.
And I'd be curious to see the number of crimes committed by new immigrants to Canada. I don't imagine that there are as many as all that. I think most new immigrants are busy, trying to learn the language, find a job, integrate, take care of their family, find health care and education. For those who, I don't think most of them want to get involved in or have time to get involved in crime. Certainly some of them do, and there probably are a few. But I don't think the number of cases would be that high. And if people commit offenses, dangerous repeat offenders, well, they're rare in this case.
If you're committing offenses over and over again and you're not a Canadian citizen, goodbye. That's a no-brainer. They should deport them. If you're hurting people, if you're violent, if you're a drug trafficker, child trafficking, whatever, like hurting women, doing what you, goodbye. And you're not from here, goodbye. That's what I think. Like he said about like the mom who's like stealing a loaf of bread. I couldn't. You gotta have a heart, right? So let's keep into it.
Mr. Speaker, I don't think there are that many. And the first cause of delinquents, whether it's a new immigrant or somebody who's been a citizen here forever, the main cause of delinquents is poor integration into society. People who don't have a job, aren't able to work or don't want to work, people who are on the margins of society, those people will often commit offenses, for example, using drugs or trafficking drugs, among other things. But if people are lost to society, if they're not integrated properly, there are social services that exist to help them and help them reintegrate society. When it comes to a new immigrant, we're also it's also important to consider the importance of proper integration. A new immigrant who is badly integrated in society, they might well be tempted by crime, by theft, violence, drug trafficking. And if somebody has not been well integrated into society, then they might well find themselves in that kind of situation. But proper integration into society for new immigrants, when new immigrants have been taken care of, when they have a job, their kids are at school, they've learned the language, those people, Mr. Speaker, they don't commit crimes.
No, that's for
And if there
sure.
are who are
No, they
committing
wouldn't.
crimes, it's incredibly rare. But what is the federal government doing to integrate new immigrants? Here we have a bill who says that new immigrants who commit a crime will send them back home. But listen, in certain cases, yes, I would tend to be agree, but in other cases, no. But what are we doing to integrate them, these new immigrants? What are we doing to make sure that they don't fall into the trap of criminality? Well, we're not doing anything. Money transfers to the provinces, there isn't any. Resources? No, there aren't any. Collaboration between the federal government and the provinces? No, there isn't any of that. The federal government determines immigration levels, and we all remember the former prime minister who, in a quite a spectacular way, invited everybody who was unhappy in the United States to just come here to Canada, that Canada would welcome them with open arms. And, he opened the bar, he sent the invitation, but he forgot to, prepare everything properly. So people, came into the country, and largely through Quebec. And why did they come in through Quebec? I think that's something that needs to be explored properly at some time. But they came in through Quebec, and the province of Quebec didn't have any choice. It's provincial jurisdiction. They had to integrate those people, pay for school. They had to help them, get winter clothes, get them health care. Parents who wanted to work, the province had to look into whether or not they had a work permit or they could work. We had to find housing. There's a housing crisis right now. And, we've talked about the housing crisis many times here in the House because of what caused, among other things, by immigration. But the federal government hasn't done anything to help integrate these people. The federal government said to the provinces, take care of it. And, before coming to the House, Mr. Speaker, I did a little bit of research on the internet on the question of new immigrants. In 2025, just a couple of months ago, Canadian-American family was risking expulsion after 15 years in Canada. 4 of the 6 children are Canadian. They all speak French. They love Quebec. They're well integrated. They want to stay. But for a reason that's not clear, the parents received a notice that they were being sent out of the country. They either have to leave and leave the kids here or bring the kids with them. It's not a great situation. And this is a family that hasn't committed any crimes. Another case here, a Mexican family, a family originally from Mexico. This was on November 5th. My colleague, Mario Beaulieu from La Pointe de l'Île, who spoke to this, and we saw it in the news. There were a family with autistic children risking being kicked out of the country. And this is a family that's been in Quebec for 7 years. 3 young kids, 2 of which have severe autism, who were born in Canada. I know my time is running out, Mr. Speaker. Another case, November 3rd, a 26-year-old man whose family's been in Quebec for a long time, and the young wife of 24 years received notice that they were going to be kicked out of the country. They have a young child. They have to go back to Mexico, and the family is going back to Mexico because they don't want to leave anyone alone. But this is what the federal government is doing when it comes to integration. So there aren't many alternatives for Quebec in these circumstances, Mr. Speaker. Either we let the federal government continue to let people come in to the province without doing anything to help integrate them, and it creates these situations that just, don't hold up, or we're going to have to make a decision. Maybe Quebec needs to have all the levers of power when it comes to immigration. If Quebec wants to get out of this situation, Quebec is going to have to be sovereign and have full power over immigration. We'll be able to take in our own taxes and use them to help people integrate into our society. We'll be able to decide who we welcome, when, where, and how they're integrated. But in the meantime, well, here we are once again. We have to deal with these poor decisions made by the federal government that create problems in Quebec, and I imagine this situation is going to continue. So, Mr. Speaker, Quebec's independence, full power for Quebec, the ability to set immigration levels and bring in taxes to help to use them adequately, I think that's the only solution to get out of this, unless the federal government wakes up and collaborates properly with the provinces and Quebec. Thank you, Mr. Speaker.
Resuming debate. Reprise du débat, the Honourable Leader of the Opposition.
Hear, hear. Thank you. Mr. Speaker, 10 years of radical open borders policies and mass migration have undermined confidence in what was the best system of immigration anywhere in the world. The Liberals imposed this radical approach without any care, consideration, or thought for the strains it would place on our housing, healthcare, and job market. And the result is chaos in our streets. But nowhere is this problem more acute than in the area of lawlessness and criminality that Liberals have invited through the system. They have allowed people to come to this country and get visitor visas and other permits to enter Canada without actually performing any criminal background checks. To this day, there are 400 criminals who have since been ordered deported but have not left and have vanished completely into Canadian society. Furthermore, our legal system now discriminates against Canadians and in favor of non-Canadian, non-citizen criminals who are here. In fact, lowering the sentences that they receive for convictions in order to allow them to stay. An unbelievable perversion of justice, which does exactly the opposite of what we should seek. It should be a stated policy of our system to get criminals out of Canada. If someone is not a citizen, not a Canadian, and commits a crime, then they should be shown the door, because becoming a citizen of this country requires good, law-abiding behavior that will protect the well-being and the interests of this country. And let me read through some examples of this kind of backwards thinking that is pervaded in our system. In the Pham decision, a key matter was that the sentence had to be reduced in order to allow the defendant to stay in the country. In 2023, in another case, a 30-year-old man, Akash Kumar Kant, tried to have sex with a 15-year-old at a Mississauga hotel for $140, but only received a conditional sentence because a stronger penalty would have hindered him and his wife's ability to obtain Canadian citizenship. On June 25th, Kant was sentenced to a conditional discharge for committing an indecent act. For 3 months, he will be placed under house arrest. During which time he was able to go shopping for 3 hours every Sunday, attend religious services, medical appointments, and travel to and from work. 12 months of probation afterwards. In other words, his sentence was specifically reduced so that he could stay in Canada. In 2024, a 25-year-old non-citizen, originally in Canada on a study permit, then a visitor permit, sexually assaulted an 18-year-old at a club in Calgary. Despite being found guilty, the court, led by Judge Anne Brown, took into account that he would be deported without appeal if the charge was one of sexual assault. Therefore, the court decided to discharge him and subject him to 15 months of probation. If he had been a Canadian, he would have been convicted of sexual assault and actually gone to jail. But as a privilege for being here as a non-citizen, non-Canadian, he had his sentence reduced to no jail time, and therefore he was allowed to stay in this country. In July 22nd, 2025, a Canadian judge hit the brakes on a guilty plea from a non-citizen linked to a homicide and facing serious criminal charges, citing discomfort with the fact that the accused would likely be deported if found guilty. Victor Buran, a 22-year-old Filipino national, was set to plead guilty on multiple charges stemming from a high-risk takedown by Barrie police earlier this year. He was arrested on January 17th along with several co-accused after officers stopped a vehicle in a North End plaza and allegedly found drugs and firearms, and yet sentence reduced to preserve citizenship possibility. In October of 2025, Roosevelt Rush, a Jamaican national convicted of smuggling 55 grams of cocaine while already on bail, had his sentence slashed in half to just 12 months from what would have been a proportionate due sentence, in part because of his immigration status. And again, on October the 2nd, 2025, a judge reduced the sentence of Ashwin Sajeevan, who was here on a study visa, to just 5.5 months in jail because a sentence of 6 months would have made him inadmissible to Canada on grounds of serious criminality. The judge specifically weighed, and I quote, the immigration consequences, end quote, for the former international student who spied on his female housemates through a peephole that he used through the bathroom wall where he made videos, recording the four of them in various stages of undress over a period of 6 months, Mr. Speaker. Example after example of where judges are specifically lowering the sentences of non-Canadian citizens in order to allow them to stay in Canada. Mr. Speaker, we welcome law-abiding, hard-working Canadian immigrants, people who want to come and productively build our country while following our laws. What we do not welcome is people who want to come here and commit crimes. And that is why I'm very pleased that the member for Calgary Nose Hill has introduced the bill on which I rise today, Bill C-220, an act to amend the criminal code, which would prohibit judges from lowering sentences or penalties on the basis of immigration status. We have one law. It should apply to every person equally. A person does the crime, they should do the time, and if that makes them ineligible to stay in Canada, then they must leave. Point final. That's just the reality. Mr. Speaker, Canadians have the right to live in peace and tranquility. They have the right to know that when they walk out the front door, they won't be harmed. They should also have the right to valued citizenship. We don't give away citizenship to anyone who comes here and breaks our laws. that arriving here as an immigrant means that there is a certain degree of responsibility, just as there is for those who are born here. And those responsibilities include following the laws, respecting others, and protecting the safety of fellow Canadians and newcomers to this country. Mr. Speaker, we believe in a system of controlled, merit-based immigration where we welcome people who want to join the Canadian family, work hard, succeed, build a better life. And the vast majority of immigrants seek exactly that. They come often fleeing violence and danger. But when they arrive here, they do not expect to be victimized by criminals who then use loopholes in order to stay in Canada and avoid penalty under the law. We as Conservatives believe Canada can once again be a safe place where all people feel that they live in peace and harmony, where their property and their persons are protected, where everyone is equal under the law, where people are held accountable for their behavior, and where most of all, the Canadian law becomes paramount, and anyone who comes here understands that following the law is the basic responsibility that is necessary to graduate from visitor to temporary resident to permanent resident and eventually to citizenship. Citizenship in Canada must have restored value, and that value starts with respecting the safety and the security of every Canadian and the rule of law in our land. Thank you.
Resuming debate. Please to debate.
The Honourable Member for Madawaska-Restigouche. Thank you, Mr. Speaker. I'm grateful for the opportunity to speak today.
So that was the official leader of the opposition, Pierre Poilievre. He is the man that would run against Mark Carney. Mark Carney's our prime minister. Pierre Poilievre is the official opposition leader who's constantly going to battle with him in question period. And today in question period was pretty good too. But so what do you guys think? I'm going to wrap this up. It's an hour. I don't really want to listen to what this Liberal guy had to say. It's in front. Might for a minute just to check it out. The other guy was so angry. They're always so angry, but like, I'm not going to wrap it up yet. So what do you guys think? I want to look at this from like, we have a conversation here, right? They're saying we need reform, and that they're letting newcomers off with lenience, even though they're committing heinous crimes, and they're getting off with leniency, and that there's basically a two-tier justice system that biologically born and natural-born Canadians are being treated with harsher penalties than people that come from away and commit bad crimes, no matter what. I mean, you shouldn't be committing terrible crimes anyway, but this is the debate, right? So I guess we've broken it down. Like, there's a difference between a mom who is starving and getting food for her child and some gangbanger who's like extorting people and like shooting place up and possibly killing people and whatever. So it's like, find that space in your heart. You know, there's a different, like, we should be deporting these evil people away anyway and welcoming the good people that want to come through the legal route to come into our country. But if they're here illegally, and especially if they're here illegally, it's like, get rid of them anyway. But, you know, that's the debate. Here we go. So I guess in closing, as I wrap up tonight's conversation, being aware of what's going on is the power that we all have. And so I just want to put it out there so you can see what's going on with this Bill C-222. Whether you agree with it or not, whether you're on the right or the left, or you're like me and just don't know what to think, the most important thing is understanding the full picture of it all and thinking consciously about the systems we participate in every day. like this judicial justice system and who we vote for and who we elect as our leaders and govern over us. We're letting these people govern over you, you know? So I just want to say thank you for being here, and thank you for staying curious and for choosing thoughtful dialogue. And in a world that desperately needs it, we need to be thoughtful now more than ever. So if you found value in this video and in this stream, and in this discussion about criminal reform and our justice system, make sure to hit the like and the subscribe button and share this video and stream with someone if you think they would appreciate it. Try to keep a balanced perspective, and for more insights and more conversations like that matter, open your heart and open your mind, and I'll see you in the next one. Take care. Thank you very much. I'll just let this fella play a bit and call it a day.
On Private Members Bill C-220, an act to amend the criminal code with respect to immigration status in sentencing, which was introduced by the member for Calgary Nose Hill. This bill raises fundamental issues for our justice system: the individualization of sentences, proportionality, parity, equality, and above all, the essential role of the judiciary in determining fair sentences that are appropriate to the circumstances of each case. It also touches on the delicate but very real intersection between our criminal justice system and our immigration system. However, far from improving this system, Bill C-220 weakens it. It would take away some of the essential discretion that judges have, and it would overturn without justification or without evidence the unanimous jurisprudence of the Supreme Court of Canada. This is something that should concern us all. According to the Conservative member who introduced this bill, the courts grant supposedly preferential treatment or excessively lenient sentences to non-citizens when they take into account the consequences of immigration, such as the loss of the right to appeal or the possibility of removal from Canada. However, the facts don't support this claim. No study, no analysis, no attorney general at the federal or provincial level has indicated that the courts are abusing existing case law. And where very small sentence reductions do occur, such as a one-day reduction, they are rare, transparent, and entirely subject to appeal. The bill, therefore, proposes a heavy-handed and rigid solution to a problem that simply doesn't exist. The bill would create a new section 718.202 of the Criminal Code, which would explicitly prohibit judges from considering any immigration consequences when determining a sentence for a person who is not a Canadian citizen. In other words, even if it's a sentence of 6 months rather than 5 months and 29 days that would automatically trigger the loss of the right to appeal an export order, the court would be legally obliged to ignore this concrete effect with significant consequences. A citizen serves their sentence and returns to their community. A permanent resident or somebody who has arrived in Canada as a child could be sent back to a country that they don't know. The judge would be forced to pretend that this reality simply doesn't exist. That's not justice. That's not proportionality, and it's certainly not what our Constitution requires. In 2013, the Supreme Court, under a Conservative government, clearly stated that immigration consequences are part of the real consequences of a sentence, and as such, they can be considered by the courts. The Supreme Court said two really important things on this subject. Yes, a judge can take immigration consequences into account to ensure that the sentence as a whole remains proportional, and that no, these consequences cannot outweigh the seriousness of the offense or the moral responsibility of the accused, whatever the Conservatives might say. This is a framework that is balanced, reasonable, it's constitutional, and it's been working for over a decade. And yet the Conservatives are now proposing that we should abolish this jurisprudence, this case law. They were in power, though, when this decision was made. They had 2 years to act if they believed this was truly a problematic situation, and they did nothing. The member for Calgary Nose Hill was herself, along with the leader of the official opposition, who was the member for Carleton at the time. Well, they were in power at the time, and they did nothing then. And what they're trying to do today isn't correct an injustice. They are trying to recycle a punitive policy that, at the time, had already been the subject of repeated constitutional challenges. And anyone familiar with criminal law knows that sentencing is based on a fundamental principle, that of individualization. Two people who commit the same crime don't necessarily have the same history, the same vulnerabilities, the same family responsibilities, or the same potential consequences.
The court already takes into account a wide range of collateral consequences for all Canadians, and not just immigrants. Collateral consequences such as job loss, the risk of homelessness, long-term family separation, impacts on mental health, and even in some cases, the inability to pursue education. Why then single out just one category, the consequences of immigration, and prohibit judges from taking this into account? This inconsistency clearly shows that Bill C-220 is not motivated by legal logic, but by political logic. The reality is that a criminal sentence has very different effects depending on the immigration status of a convicted person. Under the Immigration and Refugee Protection Act, a sentence of 6 months or more in prison automatically results in the loss of the right to appeal a deportation order. A sentence of more than 6 months or an offense punishable by 10 years results in the possibility of being declared inadmissible on the grounds of serious criminality. These consequences are not part of the criminal code. They result from a parallel administrative regime created by Parliament. Prohibiting judges from considering these consequences means accepting or even institutionalizing the fact that two people convicted for the same offense will experience fundamentally different consequences. A two-tier justice system, yes, but it is C-220 that would create it. My colleague Conservatives' bill, and not the courts. Madam Speaker, our government opposes Bill C-220, particularly because it's poorly designed, because it's not based on evidence, because it contravenes the principles of proportionality, parity, and fundamental justice, and because it would undermine judicial independence, a pillar of the rule of law. I think we could propose modifications to the criminal court. If we want to do so, we have to have a serious approach in this House. Some measures respect the Constitution, but this is not the case. There could be other measures tabled, and they could be overturned. It would be a loss of resources and a disappointment for Canadians. On this side of the House, we understand this, and that's why we're proposing truly adapted legislative measures, and they are constitutional. I'm thinking in particular about Bill C-14, which proposes a comprehensive reform of the Canadian bail and sentencing system. This bill has 80 modifications to the criminal code, which are constitutional. We want to make sure that when someone commits a crime, particularly for repeat violent offenders, that the sentences fit the crime committed. And if we're truly serious about community safety, I would ask my colleague to look at this bill. And also we're proposing C-2, which aims to strengthen security at our borders, and C-9, which is against hate crimes in our communities. And also we need to commit to better protect victims of intimate partner violence. We have an anti-fraud strategy on financial crimes, which means our seniors and vulnerable Canadians will be protected by this first anti-fraud strategy, and they need to support these initiatives. Also, we're investing in our budget 2025. We are investing in public safety, notably through our border plan, with the largest plan in the history of our country. And in my riding, we have several border crossings, and we're going to also increase the number of RCMP officers to bolster security. And also, when we talk about public safety, we also have to invest in prevention, investing in housing, mental health, youth support to reduce minor crimes and even other crimes before they happen. We're strengthening measures against those who pose the greatest risks, while investing to prevent crime at its source. And this is very important. Bill C-220 will not make Canadians safer. It will not strengthen confidence in our justice system. It will only create injustices, inconsistencies, and predictable constitutional challenges. Our role is to build a justice system that is effective, fair, and evidence-based, based on evidence and not political slogans. However, this member prioritizes rhetoric over sound evidence-based policies. Justice must not be blind to the consequences of its own decisions, and Bill C-220, however, calls for exactly that, a justice system that is a deliberately blind, rigid, and discounted system from the reality experienced by the people involved.
Of private members' business has now expired, and the order is dropped to the bottom of the order of precedence on the order paper.
Well, that is that, ladies and gentlemen. Let's call it a night. Thank you very much for watching. Whatever side you're on, where do we meet in the middle on this? Like, the Liberal Party is opposing everything that the Conservatives bring forward, and it seems like there's good things in both what both parties had to say. Like they both made valid points, but something does need to change if the case is real that there are people that are being treated less, like getting lenient sentencing. Nobody should get lenient. It should be the same across the board. So that's that, ladies and gentlemen. Thank you very much for tuning in. I appreciate each and every one of you. Keep her cool, keep her conscience. Take care. See you later, folks. Bye.